All right, here's our next topic. Something that's of interest to everybody I know, pleadings in federal court. It's really exciting. I'm sure it's going to be the subject of a TV show just before we know it. I mean, it's just riveting. I did want to start off and say this quote from Robert Louis Stevenson, don't judge each day by the harvest you reap, but by the seeds that you plant. And I hope that by attending our seminar here today that you will not only reap some harvest, but also that we'll plant some seeds, some thoughts, some maybe different ideas, different approaches to things, so that the harvest is down the road will also be bountiful. So let's talk about federal court pleadings. In the last few years, there have come out a couple of cases from the United States Supreme Court, 2007 and 2009, to talk about what has been generally reviewed as a tightened standard of pleading for plaintiffs' cases in federal courts. What these decisions have done is taken what had generally been reviewed by the bar as a loose standard of pleading a cause of action, a mere recitation of the different elements or steps or black letter law textbook factors of what you have to plead to state a claim, and said, you know, that's just not enough. We've got so many cases going, we've got limited federal judiciary, we've got limited resources in the judiciary. We need to really have the parties understand if you're going to bring a case to court, it's got to have some facts to it, it's got to have some teeth to it, and it's got to meet a standard other than just saying, here's the plaintiff is this, the defendant is this, something happened on or about this date, and the elements of the cause of action, A, B, C, D, negligence, duty, failure, whatever they are. So those are really tighten those down. And those cases are called Twombly and Iqbal. They are in your materials. The references to them are in your materials. If you have sleep problems, insomnia, difficulties, I recommend these to you highly. They've been very helpful to me multiple times, and I hope they would do the same for you. But the short answer is what this has done is kind of evidenced a greater focus among the judiciary and even some of our state legislatures of putting requirements that there's more structure on plaintiffs' cases from a variety of items, whether it's from cases that are professional negligence cases. We now in South Carolina you have to file an affidavit, and there'll be some talk about that. So additional requirements up front for plaintiffs to move these cases forward. And that's also evidenced by the mandatory disclosures that we have in the federal court system. You've got to answer these certain disclosures, who your witnesses are going to be, what your claims really are, what documents do you really have, give a list of them, you know, what can you do about exchanging them, what are you going to do about exchanging electronic information. And all this is aimed at whether or not we're going to have a greater use for motions to dismiss. Rule 12b-6, failure to state a claim. Will this standard make this easier for get the motions granted? Well, my thinking is probably maybe, but maybe not, because these cases have been out there 2 or 3 years now. The plaintiffs' lawyers are aware of the standards. They're aware of what's going on, and they're pleading their cases better, and they're doing a better job. So I don't foresee that we're going to have a raft of cases dismissed on motions to dismiss for failure to state a claim. But what you might get is make a motion failure to state a claim. You might get some of the causes of action cut down some. So you'll either narrow by the claim, or you'll maybe narrow by the parties what's going to go forward if you've got an environmental case, you know, some type of a mass tort, something like that. We've got multiple parties to it. And an interesting question is will this heightened standard apply to answers that are filed? And there's division in the courts about that. It hasn't been ruled on by the Supreme Court. Some district courts are saying yes, it's got to apply to the answers as well as the complaints. The thinking being what's good for the goose has got to be good for the gander. Fair for the plaintiff's got to be fair for the defendants. The other thought is that because the complaint gets put together and drawn after there's been investigation, evaluation, assessment by the plaintiff's counsel, that the answer is due in a very short amount of time after that, usually 20 days, 30 days, depending on your jurisdiction, what it is, you're going to have to put in maybe more defenses than you're going to want to pursue because you just don't know all the facts yet. And so you're going to have to wait and figure out your factual evaluation and your factual assessments to determine what defenses are really going to go. Some courts say, well, you can always move to amend your answer and add those defenses. Other courts say, well, it's kind of a waste of time and judicial resources, so don't amend the answers. Let them put all the defenses in, and then if they need to be cut out, cut down, pulled together, we can do that as we go. I've just mentioned briefly about the additional disclosures of witnesses, your facts, your documents, and wanted to speak just for a minute about electronically stored information. How many of you folks have had a chance or the burden to have to deal with cases where there's a lot of electronically stored information, a lot of computer information, computerized documents and things to have to fool with? If you have, you'll find out pretty soon that it is a deep well that seemingly has no bottom. There is always something more. There are always more emails. There are always other documents in other offices, on other computers, by former employees, around and around and around. And so this could be a whole seminar topic in itself, as I've said, and indeed there are seminars that talk about nothing but that. We have had the burden in a couple of recent cases to have tremendous volume of documents from our own clients' documents to get and sort through and go through, and it's a tremendous process. But it's better done sooner, better done up front, better done quicker than letting it drag out. And that's what the court systems are trying to get them to do. That's what the federal rules and the federal mandatory disclosures are trying to get folks to do, to get, like Brian was talking about with the California process, to get to a joining of the issues and determine if there's going to be a resolution or not. That's basically all I've got to say about federal pleadings, but I just can't wait to see the TV show about it. Any questions about that? So I wanted us to learn a new word today, is planting seeds. And so here's a measure of a unit of time. So we're going to learn a new word for the measure of a unit of time. What's the time that it takes between slipping on a peel and falling and smacking the pavement? The answer, 1 banana second. So next time you've got a claim slip and fall, you'll know how long it took them to fall. It's 1 banana second. You can put that in your reports. Teach somebody a new thing. My next topic is statute of limitation and repose. I don't know that they will make a sequel from this for our TV shows. Statute of limitations, I think they'll probably wait on those. It seems like statute of limitations would be a pretty straight thing. How long is it? When did something happen? What's today's date? And move on. And occasionally that's the way it works out. But it's not always that way. The timing of when something is occurred versus when it's discovered versus whether the occurrence might trigger coverage, but discovery of it might trigger the statute of limitations for defending a lawsuit. Those all have to be looked at and kind of folded together to find out if this is going to be a covered situation, or is this something that coverage will not stand for, and you'll determine whether or not you'll have to provide a defense for it, much less pay damages if that comes up. Statute of limitations, as we'll see, we'll go over a couple of things. They can vary widely from state to state. There have been changes in some of the states in recent years, and that will continue to change. And so this is kind of the, I don't know, underwriter's dream or nightmare, figuring out what the claims are, what the claims exposure is going to be, what the potential is going to be when they're taking on new clients. In North Carolina, personal injury is generally 3 years based on a discovery rule when something is apparent or becomes apparent. I've put that in there for environmental toxic tort type of claims. That's what it would be for North Carolina. However, the statute of repose says that there'll be no cause of action more than 10 years from the last act of the defendant. So the discovery rule and the 3-year rule applies certainly to a hard cap, if you will, of a 10-year rule. Not all states will have that, so you'll need to figure out what the state is and what the coverage is going to be. Construction cases is generally 6 years in North Carolina, which also the 6-year statute applies to product claims in North Carolina. And this applies to products that are bought in North Carolina. So imagine this scenario. So imagine you've got a project constructed in Rock Hill or down at the lake, down in South Carolina. You've got contractors and subcontractors from South Carolina and North Carolina involved. You've got materials supplied from South Carolina or North Carolina. Say your window units are bought as solid units. They're installed, bought in North Carolina. They're installed in South Carolina by a South Carolina subcontractor. There's leaking issues with the windows, 6 years, 7 years, and then in the 8th year, which is the statute in South Carolina, they bring the lawsuit before the 8 years run, but after the 6 years run. Well, I would say if you're not familiar with your statute of limitations and looking at what you've got, that the window installer with an 8-year statute in South Carolina has probably got something to answer for, but the window manufacturer, because the product was bought in North Carolina, has got a 6-year statute, they may have a statute defense and be able to get out. So it's not going to be apples and apples for everybody. South Carolina, as I mentioned, has got a, how did my vacation picture get on here? South Carolina's got a 3-year personal injury, 8 years for construction. Used to be 13 years in South Carolina for construction. So again, we've seen legislatures and the court systems tamping this down or bringing things down, making claims a little tougher to bring time-wise, making the claims be a little more mature, a little more complete before they get brought. I put in here Florida as well. Florida has generally got a 4 years for negligence or construction. The construction would be last date of last date of either the actual possession or the certificate of occupancy, contract complete. Latent defects would run from discovery or should have discovered, and even then there's a 10-year repose limitation at the very end.